Modes of acquiring territory in international law. The acquisition of territory in international law refers to the process by which a state obtains sovereignty over a particular territory. Sovereignty over territory signifies the right to exercise therein, to the exclusion of any other state, the functions of a state. While this right is generally exclusive, it is not necessarily unlimited, as other states may hold minor rights over the territory through treaties or local customs. The concept of title is central, denoting a legal right to territory, which may exist independently of actual factual control. The rules governing the acquisition of territory have evolved significantly over centuries, and the validity of an acquisition is generally assessed based on the law in force at the time of the alleged acquisition, known as intertemporal law. However, there is a distinction between the law applying to the creation of a right and the law applying to its continued existence, which may evolve with changes in international law. International law generally seeks to limit arguments that challenge existing territorial situations. Traditionally, several distinct modes of acquiring territory have been recognized, often borrowing concepts from Roman private law concerning property acquisition, such as cession, occupation, prescription, operations of nature, and conquest. Cession is the peaceful transfer of territory from a grantor state to a grantee state, typically formalized by a treaty, although any form of mutual understanding and consent between the states is sufficient. For a cession to be valid, the ceding state must possess legitimate prior title to the territory. Consent obtained through the use or threat of force is invalid under Article 52 of the Vienna Convention on the Law of Treaties. As a derivative title, cession means the grantee state cannot acquire greater rights than the grantor state held. Historically, cession covered large transfers, but today it is rare and usually applies to minor border adjustments to resolve historical complexities. Occupation is the acquisition of terra nullius, meaning territory that did not belong to any state immediately before the acquisition. This can include land that has never been claimed or territory that a previous sovereign has abandoned, requiring both a failure to exercise authority and an intent to abandon. Crucially, territories inhabited by organized political entities were not considered terra nullius under international law. To establish title by occupation, the territory must be placed under effective control, coupled with the state's intent to act as sovereign. The requirements for demonstrating effective control have become increasingly stringent due to the scarcity of unclaimed land. Given that most land areas are now under the sovereignty of existing states, acquisition by occupation is largely obsolete. Prescription involves the acquisition of territory that already belongs to another state. Through the continuous, undisturbed, and peaceful exercise of sovereignty over a prolonged period, implicitly or explicitly assented to by the original sovereign, the acquiring state must demonstrate its actions à titre de souverain. Compared to occupation, the period of effective control required for prescription is longer, and the relinquishment of title by the former sovereign is not easily presumed. The losing state's acquiescence is essential, and protests can prevent title acquisition. While controversial due to the lack of a fixed time frame, the concept is sometimes recognized as a general principle of international law, often merging with tacit agreement or acquiescence. States can acquire territory through natural processes. Accretion refers to the slow, gradual increase of land, such as river deltas silting up or volcanic islands forming within a state's maritime zones. These changes must occur naturally and gradually to impact territorial title. Sudden or violent changes, known as avulsion, typically do not alter boundaries unless otherwise agreed. Historically, military conquest followed by annexation was a recognized means of acquiring sovereign title. However, with the evolution of international law in the 20th century, culminating in the UN Charter's prohibition on the use of force, Article 2, Tot 4, conquest is no longer a valid legal mode of acquiring territory. The 1970 UN General Assembly Declaration on Principles of International Law concerning friendly relations and cooperation among states explicitly states that no territorial acquisition resulting from the threat or use of force shall be recognized as legal. Any treaty of cession imposed by an aggressor through force is also invalid. In addition to these traditional modes, other principles and circumstances are highly relevant to territorial claims. They are 1. Adjudication and arbitration, 2. Acquiescence, recognition, and estoppel, 3. Historical consolidation, 4. Novation, 5. Discovery and symbolic annexation. 6. Uti possidetis juris. 7. Critical date rule. 8. Geographical presumptions. 9. Polar regions. And 10. Leases and servitudes. Adjudication and arbitration. While frequently listed, adjudication by international tribunals typically declares existing rights rather than creating new ones. Thus, its status as a direct mode of acquisition is doubtful. Acquiescence, recognition, and estoppel. These are crucial evidentiary rules that play significant roles in solidifying territorial claims or curing potential invalidities, though they are not modes of acquisition themselves. Recognition can be expressed or inferred from a state's failure to protest, and it gains weight when accompanied by actual control over the territory. Historical consolidation. This doctrine allows for a de facto situation, even if initially unlawful, to become legally consolidated over time due to a prolonged absence of opposition, ensuring stability in the international legal order. The International Court of Justice, however, has indicated that it cannot replace established modes of acquisition. Novation refers to the gradual transformation of a right in territorio alieno, such as a lease or pledge, into full sovereignty without a formal instrument. Modern international law principles make this mode highly unlikely today. Discovery and symbolic annexation. In earlier centuries, mere discovery was sometimes sufficient for title, but modern international law requires subsequent effective occupation to consolidate such claims. Symbolic annexation, such as flag planting, may establish title only under special circumstances, as illustrated by the Clipperton Island arbitration, uti possidetis juris. A fundamental principle, particularly in decolonization and state succession, which dictates that borders existing at the time a state gains independence are recognized as international frontiers. This principle prioritizes legal title over effective possession. Critical date rule. A procedural rule stating that events occurring after a territorial dispute has crystallized will generally not be considered in determining the parties' rights. Geographical presumptions. Principles like geographic unity or contiguity are often invoked to justify the extension of sovereignty from one territory to an attached or nearby one. However, these serve as aids to reasoning rather than definitive principles of law and are subservient to stronger claims of sovereignty. Polar regions. These areas present unique challenges. The Arctic region is subject to claims by surrounding states, though this sector theory has not been widely accepted and was dismissed by UNCLOS 1982. The Antarctic is governed by the 1959 Antarctic Treaty, which imposes a moratorium on territorial claims and designates the region for peaceful purposes, reflecting its status as part of the international commons. Leases and servitudes. These represent minor rights over territory rather than full acquisition of sovereignty. Leases grant exclusive jurisdiction to the lessee state for a period, with residual sovereignty remaining with the lessor. Servitudes involve one state's territory serving the interests of another, allowing certain actions or compelling abstention from others. In conclusion, in contemporary international law, the determination of territorial title often involves weighing the relative merits of competing claims based on state conduct rather than making absolute determinations.